Hello and welcome to Legal Briefs. It's the Monday afternoon edition, and over the weekend, something unexpected happened. John Deaton and his 67,000 XRP holders arrived in the Ripple versus SEC case in style. It was a very emotional moment for me.
There's just too many of them.
But there are more of us, Poe. There are more of us.
Star Wars is just perfect for this case. There's an evil empire, an emperor, and a ragtag group of rebels fighting the establishment. Welcome back. Yours truly, Jeremy Hogan. And for the past 2 to 3 months, we have been focusing on the deliberative process privilege, and more recently, the SEC's attorney-client privilege argument, in which the SEC is desperately trying to not turn over 68 emails related to the Hinman digital asset speech. And the attorney-client privilege issue is fully briefed now, and it's with Judge Netburn for her determination, and we'll be patiently looking for that ruling later this week, although based upon her past rulings, it might be 2 weeks, which puts us into early June. Now, can you believe it's June already, and the Ripple case is finally entering the endgame of the case? I'd say in the Avengers movie, all that time travel stuff is over, and we are right now around the final battle scene where everyone finally comes through the portals. I was going to put John Deaton's face on Black Panther, but God intervened and saved me from that bad decision. Thank you. But in any case, let's talk about this new phase of the case involving expert witness reports, why it's so important, and why Deaton's motion is crucial. As you know, the parties have to file their motions for summary judgment in November of this year, but before that, on August 30, 2022, the parties must submit their motions to exclude expert testimony. In most U.S. court systems, the court maintains control over what expert testimony is allowed in and what isn't. An expert witness is someone who has special knowledge, which allows her to provide opinion testimony to the court. Now, you can't bring in your uncle to talk about how an accident happened, for example, because he has no more knowledge about those type of things than a regular jury. But you can bring in an engineer who has training in accident reconstruction and who analyzes the damage to evaluate how fast the cars were going and looks at the angles of the cars to talk about how the accident and where the impacts occurred. So, for expert testimony to make its way in front of a court, you need 2 things. You need a person who is qualified as an expert, but also the expert's analysis must be the result of sound scientific methodology. And that attack on scientific methodology in federal courts is called a Dalbert challenge, because the name of the case that established it was the Dalbert v. Merrill pharmaceutical case. Now, it is a Dalbert challenge which is brewing in the Ripple case, and in which the Deaton Amicus Brief might make the difference in the case. Let's talk about that. As you know, the judge granted XRP holders amicus status, but they still have to make a request to the judge before doing anything. And here in this motion, Deaton requests leave of court to file an amicus brief in a Dalbert challenge related to the expert opinion of a Mr. Duty. Let's look at page 1, it's right there, quote, "Amici respectfully request leave to file an amicus brief regarding the opinions of plaintiff's expert Patrick B. Duty. Dalbert concerns related to Mr. Duty's opinion represent the precise nature of the difficult issues envisioned by the court when it granted amici status. Counsel for amici recently became aware of Mr. Duty's report regarding the conduct of individual XRP holders such as amici," close quote. So that is apparently what is upcoming, a Dalbert challenge on a Mr. Duty. And how do we know, and how does John Deaton know what Mr. Duty is going to say when we and he hasn't even seen the report yet? Well, we know because the SEC is a repeat customer of Mr. Duty. They have used him before, and specifically the SEC hired Mr. Duty in the Telegram case to very good effect. And here we have obtained a short clip of Mr. Duty's actual testimony at trial.
"In the daytime or night, look around left and right and cross the street with your eyes."
Cheap shot. You know, I just don't care anymore. No. Actually, here is Mr. Duty's report for the SEC in the Telegram case, and here it is in his introduction that he talks about what he was hired by the SEC to do, and let's look at paragraph 1 under assignment. Quote, "The SEC has retained me to independently analyze and opine on the perspective of a reasonable purchaser of the digital tokens called grams," close quote. And then just below that, he talks about his qualifications. That's essentially where he qualifies himself as an expert. And then if we go down to page 3 under summary of findings, guess what Mr. Duty's opinion is? Quote, I conclude that it was reasonable for purchasers to buy grams in round 1 and 2 with the expectation of profits derived from the work of Telegram in delivering and developing the TON blockchain system, close quote. So, no surprise there. The SEC's expert concludes that purchasers expected profits from the efforts of others. And even though we haven't seen his report in the Ripple case yet, I can guarantee you with 1,000,000,000,000,000% certainty that is exactly what he's going to say again. And this is likely to be a vital report for the SEC because outside some kind of loose and lazy inferences from Ripple's marketing materials, this report will really be the way that the SEC ties the purchase of XRP to an expectation of profits from the efforts of Ripple, which is a key part of the Howey test. This report will go to the heart of the case. And when I looked at the Telegram case summary judgment order, which is from the judge, I was actually quite surprised to see how much the judge there relied on the duty report in making his ruling. Now look at this from the Telegram order. This is the paragraph from the judge. Reading from page 26, quote, this provision created the reasonable expectation among initial purchasers that even if the market price of grams fell, the TON Foundation would support a market price that would enable the initial purchasers to sell their grams at a considerable profit, referencing duty report paragraph 40. And that's just one example of 10 references in the order to this report. So it's a big issue. Ripple will apparently be moving to strike this report, and it must show 3 things in order to strike an expert witness report, but the most important for our discussions is that Ripple must show that the opinion is based upon, quote, insufficient facts or data, and that the methods used to arrive at the opinion were not reliable. And what is the most striking thing in the duty report? If you look at the Telegram one, the most striking thing is that Mr. Duty gives an opinion about what purchasers are thinking when they buy the digital asset without talking with any actual purchasers. Let me repeat that again. In the Telegram case, his opinion talked about what purchasers were thinking without actually interviewing any purchasers. Now to me, that is a pretty bad omission, and maybe he's going to fix that omission in his Ripple report. Maybe he's even spoken with a couple individuals that he kind of were handpicked by the SEC to say, of course I was relying on Ripple to increase the value of my XRP investment. Maybe Mr. Duty did that, but I doubt it. We'll see. But what I do know is that the XRP community has come through big time for Ripple, and now the court knows it as well. Let's take a look at Deaton's motion at the bottom of page 4. Quote, knowing Amici is excluded from presenting facts and evidence to the court, counsel for Amici provided the parties with the relevant facts and evidence Amici would present if allowed. And then, look down at the footnote 5, quote, the parties have been provided with 3,252 affidavits from XRP holders from the United States and abroad attesting to matters, close quote. Over 3,200 affidavits. Good job, XRP community. And also Attorney Deaton, where he gets the time, I don't know. He's like a lawyer sorcerer. So the parties have the 3,200 and change affidavits because Attorney Deaton gave it to them. That would include the SEC. So now having the affidavits, of course, the SEC has now agreed to work with the Amici XRP holders to get this important and relevant information in front of the court, right? Wrong. And although that might be unfair to the SEC, since obviously those affidavits are probably not going to help it, at least you think they'd agree to allow the Amici to see the duty report so they can make a meaningful contribution, at least in their briefing, right? Wrong. Actually, when approached by Mr. Deaton, Ripple agreed to meet and work with the XRP holders on this issue, but look at how the SEC responded to that request. It curtly says, quote, moreover, we note that the court has limited Amici participation to legal as opposed to factual issues and see no reason to share discovery material for this discrete purpose, close quote. In other words, we're not working with you at all, Deaton, even though you represent 67,000 of the people that we also are supposed to represent. Which brings us to the big issue in the case or in this motion, which is, will the judge grant the motion for the XRP holders to file their amicus brief? And the answer is yes, I think so. And it's because, as Deaton very eloquently says, quote, allowing Amici to brief legal issues surrounding the opinions of Mr. Duty epitomizes the type of assistance the court contemplated when it granted Amici status and stated, quote, such assistance will be most beneficial during briefing on dispositive motions, but may exercise its discretion to request or deny further applications as appropriate, close quote. Motions related to Mr. Duty's opinions could prove dispositive when applied to the SEC's sweeping allegations regarding the XRP acquired in today's secondary market. Amicus participation will help ensure the complete and plenary presentation of these difficult issues and will aid the court in its gatekeeping function, close quote. Very well said, Mr. Deaton. Now, my only concern with this motion is the timing, and that's because no actual motions to strike the expert witnesses have been filed yet. They aren't due until August 30. But Attorney Deaton really had to try and file this motion now, because if he waits until August 31st, he'll be left with just a month and a half to file his motion, get court permission, draft and file his brief, and that's cutting it close time-wise. So I think the judge does grant this motion eventually, but she may deny it initially and tell the amici that they have to wait until the Ripple and SEC briefs are already filed before she'll grant it. We'll see about that shortly. Thanks for watching, and allow me to say happy 79th birthday to my dad, who you might remember from his guest appearances in some of our videos.
Hello, this is Attorney Jeremy Hogan, and welcome to Legal Briefs.
He's a great father and a good sport for putting up with my silliness. Love you, Dad. Plaintiff's expert Patrick B. Duty. A dalbert challenge on a Mr. Duty. And how... It's kind of a cheap shot, but what the hell?
It's really not fair for him.
Yes.